The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, not getting an invoice. I'm Simon Jenga, and welcome to Simon Said. Today we are talking about the difference between enduring powers of attorney and standard powers of attorney. So let's start with standard powers of attorney. These are documents where one person appoints another person to act in their place. Now, it can be in relation to a specific transaction or a specific set of actions, or it could be general authority to sign on that person's behalf. A really common restriction that we find is if someone is going overseas and they want their spouse or a family member to be able to proceed with a transaction, such as a sale or a purchase, then the power of attorney will allow for the attorney to make decisions and take actions in respect of only that transaction. And depending on the nature of the transaction or where it is up to in the process will dictate how specific that power of attorney document can be. So if there's already an unconditional agreement, it might be just that they are signing the documentation to complete settlement. If there's still negotiations ongoing, then it would be that they are authorised to engage in those negotiations. And whether they need to consult with the donor of that power, that would be included in the document. Now, often hand in hand with a power of attorney is a deed of delegation. And the deed of delegation allows for a trustee to be able to have someone else make decisions in their capacity as trustee. However, there are strict restrictions on the exercise of a deed of delegation. The two poignant ones are that the donor is either overseas or that they are physically incapacitated. It does not include mental incapacity. It only includes physical incapacity. So for example, they are at the hospital and they physically can't get to the lawyer's office to sign, or they physically can't get back from Queenstown to Tauranga to be able to sign documentation. But as soon as that person doesn't have mental capacity, the deed of delegation can no longer be used because it only applies to a donor that has capacity at the time when a decision is being made. And that applies for the power of attorney. It only applies when the donor of the power still has capacity at the date when power is being exercised by the attorney. Now that is in contrast to an enduring power of attorney. Clue in the title, enduring power of attorney. It endures mental incapacity. That is the reason for that language. So it survives someone losing capacity. Those appointments as attorneys are still effective. And that is fundamentally the difference between a standard power of attorney and an enduring power of attorney, is that a power of attorney ceases on incapacity of the donor, whereas the enduring power of attorney persists. And in fact, there's elements of the enduring power of attorney that only kick in if someone loses capacity. So for mental care and welfare, that will only kick in if someone is judged as lacking mental capacity to make decisions for themselves. For a property attorney under an enduring power of attorney, the document can be drafted either way. It can be drafted that it is effective whilst the donor has capacity and continues if they lose capacity, or alternatively it can be drafted to only kick in if there's a loss of capacity. Now, as a side note and a general principle, my recommendation is always to allow your property attorney to act whilst you have capacity and then continue to act if you lose capacity. And the reason for that is very simple. If you trust someone to make decisions once you have lost mental capacity, then in my opinion, you probably are going to trust them with having the authority to make decisions while you do have capacity. The other silver lining is that if they do anything weird or wonderful or indicate they'll do something weird or wonderful, then whilst you have capacity, you could still remove them by revoking those documents and replacing them with a different attorney. So it gives you far more flexibility. The other thing that does happen is that when you are teetering on having capacity, so it might be that you have dementia, you don't have Alzheimer's, you've got early onset, It's unclear whether you do have capacity to make your own decisions, but you really need help managing your affairs. You need help down at the bank, you need help with the property sale, you need help with decisions. If your property attorney has authority whilst you have capacity and it continues, then they can help you through that process without needing a medical certificate to authorize them to engage and have authority. So again, that can be really helpful, take a bit of stress and pressure off the subject person or the donor at a time when they are losing capacity, losing the ability to make their decisions, and most likely becoming more anxious and nervous around big decisions anyway. So it's kind of a nice happy balance. That fundamental difference between the two documents means that they are relevant in completely different circumstances. So enduring powers of attorney are part of your estate planning, effectively. What is going to happen if I lose capacity? Who is going to look after me? And who do I want to be making decisions on my behalf, both whilst my spouse is alive and also if my spouse dies or loses capacity themselves? Who then? Who's the backup? Is it my kids? Is it my brothers and sisters? Are my parents young enough to take on the role? And if I don't have those, well then who's next? Nieces and nephews, friends, wider family, lawyers, accountants, financial advisors. There's a number of options, and what you're looking for is your trusted person to step into your shoes and make decisions. They're not making decisions on your behalf, they are making decisions as you. It's an incredibly important role, and it's part of that administrative process of putting in place your estate affairs, both for now and the long term. So that's the focus of enduring powers of attorney. Powers of attorney and deeds of delegation are relevant to whilst you have capacity and you're operating in the world. So they often come up in the context of businesses where someone is a director of a company and they want to be able to appoint someone to make decisions whilst they're overseas or if they're unavailable. That's a very common one. Sometimes it's between spouses being able to make certain decisions. That's less common in the modern age. It seemed to be more common in years gone by. And it's really about, if I'm not able to make decisions or I'm unavailable, how is the company going to continue operating? How are my affairs going to continue operating? Who's going to be in charge? For a lot of people, it's just not a relevant consideration. For some people, it becomes important, particularly if things hinge on the timing of needing to make decisions in a big business context. With the way the world is interconnected and the ability to travel to Timbuktu but still have internet connection and sign documents and video, the necessity for powers of attorney has kind of shrunk. But there's still circumstances where it's relevant, and it's going to depend on each individual specific circumstances. The other main difference between powers of attorney and enduring powers of attorney is the compliance obligations around execution of those documents. So powers of attorney are far more laxical in terms of the requirements for signing. You need to sign as the donor. The attorney that you're appointing doesn't actually need to sign, and the donor simply needs a witness. So it doesn't need to be an independent witness of the attorney. It can be anyone who is an adult that is independent of the donor. So it can't be a family member, for example. Compare that with executing an enduring power of attorney. The Protection of Personal and Property Rights Act 1988 sets out very clear and very strict requirements for the form of the document and the execution of the document. So in terms of format, it has to be on the prescribed form. Law firms take their own flavour and their own flair, have their own precedent versions, but in substance, every single law firm in New Zealand is generating the exact same content into an enduring power of attorney. So it's a prescribed form that's got a, let's call it a smorgasbord of options. So you have all these different restrictions that could be put in place, different provisions that are this way or that way, and you get to pick which one applies. Now, the policy reason for requiring all of that information to stay in the document, even the options you don't pick, is so that the donor has notice of what the different options were. So when the precedent format changed back in, I think it was around 2010, basically part of the commentary was that lawyers were stripping back the documents to what they were advising the client they should do and not giving enough information around what the options were that were available to the client. So the remedy for that is to require that all of the options have to remain in the document and can't be deleted. They can only be struck out. That's taken these documents from being one page back in the early 2000s to being 15, 14, 13 pages now, with lots of information. Downside is complexity of the document. It's harder, in my opinion, to understand and read the documents, but the upside is that you get far more information up front about the document you're signing so that you can be well informed both by the document itself together with your lawyer's advice and comments. So there's kind of swings and roundabouts as to whether it's better or worse, but definitely there's strict requirements around how that document is to be signed and what that process is. The other main restrictions are that the donor's signature must be signed by a registered legal executive or a lawyer or a JP. So it's very restrictive in terms of who is witnessing the signature. And the other restriction is around conflict of interest. So if we are acting for mum and dad, or dad and dad, or mum and mum, whatever the case may be, then as long as that couple are appointing each other, then we can act for both parties in drafting the documents and witnessing their signatures, as long as we don't identify any other risk factors. So that's no problem. As soon as one of them is appointing someone else, becomes a conflict of interest under the terms of the legislation, and even though we can prepare all the documents, we have to send people out for independent legal advice. It may seem over the top, but that's the position that we're in. That also applies if mum and dad appoint each other and then appoint their daughter as the backup, but our law firm acts for the daughter. That has now presented a conflict of interest between the daughter's interest as attorney, who we act for, and the parents as the donors of that power, who we also act for. Again, the legislation dictates that we are unable to waive that conflict on the basis that we don't think that it has a material impact on the parties or the advice that we're giving or their position generally. We're unable to do it. We must send mum and dad out for signing at an independent law firm. So again, we can prepare everything, but the client needs to go out for signing. It's unfortunate, it's annoying, it's there for a purpose, to protect people, to make sure that the appointments are valid and above reproach. And also the other comment that I would make on it is that from a cost perspective, generally, if I'm sending someone out to get signing, what I would have charged them for preparation and signing, they're roughly going to pay the same amount with paying me for the preparation and the other lawyer for the signing. It might be slightly higher, but generally we try and work it so that it's about the same, because ultimately we want you to appoint the people that you want to appoint and not be making decisions based on costs alone, because that's not a great way to organize your legal affairs, generally speaking. So we want you to be thinking in terms of, who is it that I want to appoint? I want to be focused on that decision. I want to appoint the right person. And if we can manage it so that the costs become not a factor at all, then that's a huge bonus. So today, Simon says the difference between powers of attorney and enduring powers of attorney can be simply summed up as enduring powers of attorney endure someone losing capacity. And remember, at LOA Law, we are good lawyers for good people.